Welcome back to the Born to Fly Law School video series. This is video 4 of our series. Today we will be beginning the basics of class preparation. Part 1, understanding the law. The subsections of understanding the law will be the abstract theory versus the practicality theory, the conflict pairings, basic legal principles, and then lastly we'll get into legal analysis. So again, we have attorney Emmanuel Obi, starter of the Obi Law Firm here in Dallas and actual author Born to Fly. Let's get it going.
All right. Okay, I know you guys are tired of seeing me, so we'll try to keep this one short. But again, just a quick series of videos that we put together to help you as you prepare for and as you go through this law school process. We're hoping to roll out a series of other Born to Fly type events, including online chat rooms and various ways that we can provide the critical support that you need. The one thing that I want to say before we get into the material is that please do not make the mistake of thinking that you are in this process alone. Law school is a very difficult but not is a very difficult and challenging process, but it's definitely one that you are ready for and definitely one that you can tackle as long as you make sure to make good use of the resources that you have available to you. If you're here in Dallas, please reach out to the J.L. Turner Legal Association. One of my primary objectives as the incoming president-elect is to increase the pipeline and the numbers of African American and minority students that are going to law school, performing and ending up in the top of your class, and then coming out and having all sorts of opportunities to do well and to give back to our communities. So with that little nutshell out of the way, Mel, I give it to you. Looks like we're covering a lot today. We're covering the abstract theory versus practical reality. Okay, that's an important distinction. Then we're also going to cover conflict pairings and why that's particularly important as it relates to your study and your preparation for law school. Then we're going to talk about just some basic legal principles, and we're going to talk about legal analysis and how you should go about doing that. So, Mel, with no further ado, I'll hand it over to you, my friend.
All right, so let's get started. First, what is the abstract theory?
Here's the thing. One of the things that took me a while to get a handle on in law school, and it's something that I wish somebody had sat me down and talked to me about, is and you'll hear this, you'll be in class and you'll hear the folks who will answer the questions and who will say, well, back in ancient, Egypt, the jurisprudential landscape developed from, this and that. That's important. That's important. That's important. But as you're preparing for your exam, you have to make sure that you're focusing on the practical reality that you're going to be taking an exam that is written by your exam professor. Okay, so you're going to get all sorts of cool stuff about the theory and about the concepts from all sorts of supplements and horn books and all sorts of things. So you're going to get lots of that. But the practical reality is that your exam will be written by that professor, and your exam will reflect what that professor feels is important for you to master to make a good grade in their class. So as you're ingesting the abstract, the abstract theory, never lose sight of the practical reality that at the end of the day, your examination and your test will be administered by this one person, this professor, and so you need to be working on developing an understanding of what they feel is important, an understanding of what they feel is testable, an understanding of what they feel students in their class should come away with.
What is conflict pairings? Could you give some example of legal conflict pairings?
Yeah, this is one of the things that I think law students in the very early process of developing an understanding of how to approach law school, you don't have a sense of, because it's something that you've never really had to do. And that is, you always have to remember that part of the process of thinking like a lawyer is developing a comprehensive analytical approach. And so you can never come up with a comprehensive analytical approach if you're looking at situations from your vantage point only. For example, when I have a client that comes to me and says, hi, I have this issue and I need your help to get this issue resolved. Maybe they're trying to do a deal with another party. Maybe they've got a lawsuit that they want to file against another party. Maybe a lawsuit has been filed against them. Legal issues tend to come up in conflict pairings. That is, there are two sides of that legal issue. There's one side that's the plaintiff who's bringing a claim. There's another side that's the defendant, typically, who's defending a claim. And whenever you're doing legal analysis, if your analysis is only focused on the plaintiff's side, or if your analysis is only focused on the defendant's side, and you present this type of analysis on an exam, I guarantee you that you're not going to make the top score. Part of thinking like a lawyer is an analysis that delves into that conflict pairing and says, okay, the plaintiff wants to bring a lawsuit. Let me give you a practical example. Let's say you have an exam question that says, it gives you a set of facts and it says, the plaintiff now wants to sue for breach of contract. Can the plaintiff sue for breach of contract? And you go through, you're like, yes, this is great. I know this. I'm the plaintiff. We're on the offensive. And you go through the analysis. Yes, there was a contract. There was an offer. There was an acceptance. The plaintiff did this work. And then the plaintiff, submitted the check to get paid. And then the plaintiff never got paid. And then the plaintiff has made so many demands. And the plaintiff has not gotten the plaintiff's money. So now the plaintiff is conclusively 100% entitled to their money. What's wrong with that analysis? What's wrong with that analysis is that it's completely from the plaintiff's standpoint. You've articulated how the plaintiff has met the elements, but have you argued how the defendant may argue against all of the elements being satisfied? You've articulated how the plaintiff is entitled to payment, but have you articulated any basis that the defendant may have for seeking to not pay the plaintiff? You've articulated that the plaintiff has suffered some harm, but are there any counter arguments that the defendant may have on that subject? So when you think about conflict pairings, it's a very key analytical trick to get your mind to know and to train your mind that when you have legal issues, you have to analyze those issues from both sides. You have to look at both perspectives. And if your analysis on an exam does not reflect that dual perspective kind of back and forth tennis match, and that's actually a good analogy that I use a lot of times, is that a good law school exam is like the written version of a tennis match. Why? Because with each argument, there's a counter argument. With each argument, there's a counter argument. And then at the end, somebody's got to win the match, right? And so as you're moving through it, somebody serves. Maybe the plaintiff serves. The plaintiff is filing a lawsuit. The defendant is going to return. And then you just keep going back and forth until you get to the point where you say, okay, who scored the most points? Who wins the analysis? Who's supposed to win the case? So conflict pairings are extremely important. Every single issue that you will have, mostly every single issue that you will have as a law student, you need to evaluate in the context of a conflict pairing.
All right, let's move on. Basic legal principles. What are some legal principles that an incoming 1L student should know? And secondly, are there any materials that have these principles laid out for me?
Yeah, that's a real good question. I'm not going to spend a lot of time on that, but one of the things that you should know, one of the things that you should spend a lot of time getting used to in law school is the idea of how our court systems work and the development of case law, and how the development of case law impacts the law that is the binding law in your jurisdiction. That's something that you'll spend a lot of time in legal research and writing, understanding the hierarchy of our legal system and how the courts are related and what court is higher than what court and what authority is binding authority and what authority is mandatory or permissive or discretionary authority. So that's one thing. The other thing that you should keep in mind, or the principles, is that the legal system is a system that has a lot of policy that underlies it. And so a lot of times in law school, if I ever got stuck on the actual rules, or if, let's say you're taking an exam and you are in a torts exam and you're trying to remember a rule about, or a case about how a rule or how a set of facts should be interpreted, maybe you don't remember it, maybe you're freaking out and you don't remember it, but you do know that the basic policy of torts is to compensate the victim and make the victim whole, and to deter and to make sure that there's an equitable result. So even if you end up having to resort to that as a last minute deal instead of actually writing about the cases or about that's still going to get you some points. So what am I saying? What I'm saying is, as you review your classes and as you go through each class, contracts, property, legal research and writing, civil procedure, torts, crim law, there are very distinct principles and policies and things that are advanced by each of those classes. Make sure you develop an understanding of those and use them to the extent that they can to help you not only develop an understanding of the material, but also when you're on the exam and you're working and you're trying to make a good grade.
All right. Lastly, we have legal analysis. Now, since most people going into law school don't really have a good understanding of the law, what's a good approach to analyzing such new material? And also, how should I use this material or this analysis of the new material on an exam?
Yeah. I don't know where everybody's going to be in terms of the semester. I'm assuming that a lot of you that are going to be watching this, assuming anybody watches this, you're going to be in the very beginning stages of your deal. And so what I want to say about legal analysis, a lot of what I've already said is really what I would probably say about legal analysis, which is it takes place in the form of conflict pairing. So you have to always remember what are your conflict pairings. It has to be a balanced analysis. Law school exams and professors are notorious for giving you fact patterns that pull to the heartstrings in one way. For example, a torts professor can give you an exam that says, little Johnny is 4 years old, and little Johnny lives in the neighborhood. And in his neighborhood, there's a big fence that separates his neighborhood from a nuclear waste plant. And one day, little Johnny was walking in the neighborhood, and there was a hole in the fence that separated the nuclear plant from the rest of the neighborhood. And little Johnny, some kind of way, found his way into this hole. And then little Johnny walks up to a big vat of nuclear waste, and unfortunately, little Johnny, being curious about the glowing nature of the ooze coming out of this barrel, climbs into the barrel or tries to climb on top of the barrel. It falls on him, and now little Johnny has been horribly disfigured by this acid that is poured all over his body. And then a fact pattern will say, you represent little Johnny and his family, what claims can be brought, and how would you go about bringing those claims? Now, you read that fact pattern and you're just like, oh my goodness, this big bad nuclear reactor company has to go down. Look what they did to little Johnny. And you start going at it on your laptop, typing up all of the negligence and intentional things that you can go against this nuclear company. But in order for that analysis to be full and wholesome, you also have to predict and think about, well, what are the defenses that this company may have? Is it an assumption of risk? Did little Johnny make a conscious decision to go into that? Is it maybe little Johnny's parents for failure to supervise little Johnny, for failure to provide adequate supervision, and that's the reason? Can they really prove that little Johnny or the fence, maybe somebody else made a hole in the fence? Maybe the hole was made by somebody, or a gardener, or somebody who was doing yard work the other day, and they're really the ones that should be liable because they created the hole. What I'm saying is, legal analysis, thinking like a lawyer, the Socratic method, all it is, and when you think about it, the whole classic vision of what we think about when we think about law in terms of the scales of justice is kind of fits into this. Because at the end of the day, it's all about looking at both sides of the equation, and seeing, okay, this side wins because the evidence is a lot heavier, or no, this side wins, or oh, maybe it's a tie. But at the end of the day, the key thing is you have to have balanced analysis. You have to go through this systematically. Now, in order for you to do that in law school, you have to come up with a system that allows you to absorb this material, because there's going to be a ton of material. And for me, my system was as follows. Daily, you need to review. Absolutely daily. You're going to go to classes every day, you're going to take notes, and you're going to get information in those classes. So get in the habit of reviewing your notes daily. Just printing them out, if you're writing your notes, every day you review your notes and review what you've studied in that class. Then I would also weekly review my notes for the week. My study group and I, we had a killer system where every Saturday in the library we would meet for 12 hours straight, and we would systematically review all of the new material that we had covered in the previous week. And I will submit to you that that worked for us, because in my study group you ended up with the valedictorian of our law school class, and then you ended up with me and another friend of mine who both graduated in the top 2% of our classes. And so that system was very effective for us because it was no nonsense. Every day we would review. Every Saturday we had a set meeting where we would come starting about 8 o'clock in the morning, and we'd review every class. And then at the break of every chapter, the logical break in the material, once you finish all the negligence material, then you go back and you review all the negligence stuff. Make sure that you review it. And then you go, maybe you finish intentional torts, and then you review all the intentional torts, and then you review all the negligence. And then maybe you go into products liability, and then when you finish that, you review all the products liability stuff, then you review all the intentional tort stuff, and then you review all the negligence stuff. So by the time you get to the end of the year, you have reviewed this material over and over and over again to where it has become second knowledge. It's become something that is now part of you. You've mastered it. You own this material. In addition to that, you also have to systematically outline. Outline, outline. That's like a word that you're going to hear a lot of in law school. Outlines are just outline, outline, outline. A couple of things on outlines. I don't know if we have a separate deal on outlines, but so look forward to the separate presentation we have on outlines. But so you're reviewing your materials daily, you're reviewing your materials weekly, you're reviewing your materials at the end of each topical break, and then you're taking all of that review and you're packaging it up into your outlines. Your outlines will then become what you use to prepare for the exam. All right, well, final note about day-to-day preparation in law school is do not allow yourself to focus on the trees to the exclusion of the forest. Like a lot of times students get into tunnel vision. You get so focused because the Socratic method gets you so scared that you're spending an inordinate amount of your time preparing for class. Preparing for class is only a fraction of what you need to do if you want to end up in the top 10%, top 2%, top valedictorian or whatever of your class. You have to prepare for class, but then you also have to make sure you're systematically, every single day. Listen to me very carefully, everybody. If you want to end up in the top of the class, and if every single day you are not doing something that is somewhat calibrated to preparing you for the exam, you're going to have a hard time ending up in the top of the class. Okay, so we've got another session coming. Hang in with us. I know you're tired of seeing me, but hopefully maybe we'll get somebody else in here to switch it up a little bit. See you next time.